Good evening, everyone. I hope everybody you are doing very good. All are well, and here it is very cold. I hope you, wherever you are living, you all are very safe and okay. So let's get started. In the last class, that was on Friday, we completed the concept of Partnership Act. Okay. So today we'll be starting another new act, and the name of act is Limited Liability Partnership Act. Limited Liability Partnership Act 2008. This is the name of the act. So basically, this is also a partnership act, and in the last class we also studied partnership act only. Then why there is difference? Why there are two different partnership acts? To overcome such doubts and problems, we'll be discussing this chapter today, and we'll be completing this act today itself. Okay. वैसे तो if we go to deeper sections, it is a very big act, but only a small, I can say only 1/4 part of the act is in your course. Okay, so only the basic principles of the act are in your course, not the detailed act. Okay, when you'll be moving in future classes, there you'll be finding detailed portion of this act. Here it is a very small portion that is in your course. Okay, so it is on page number 196. Page number 196 of your modules just after Partnership Act. I repeat, page number 196 just after your Partnership Act. Okay, so before starting the concept of limited liability partnership, let us discuss again what a partnership was. Partnership was where there is mutual agency between two or more people who have come together to do a certain type of business, right? And their liability is unlimited. That is, even their personal property can be taken into account if there is any insolvency issues or something like that. Okay. On the other hand, there is one more concept of business organization, and that is a corporate company. Okay, corporate you can say, or company you can say. So there is one more concept of company. Company is a very different concept. In wider concept, if I talk in a wider sense, what a company is, that I will not discuss here because we'll be doing a separate act, complete companies act in future. Okay, so in brief, if I tell you, a company is a corporation that has perpetual succession, and it is a separate legal entity. Okay, so what is the meaning of perpetual succession and separate legal entity? Separate legal entity means company is in itself is an artificial person. A company can file suit in its own names. It does not require members to file suit in for any issues. A company has a right to file case against anybody in their own name, and third party can also file a case on company's name. Okay, so this is the concept of separate entity. So basically there are many more concepts in company. So why I am discussing company and partnership here, the reason behind this is the Limited Liability Partnership Act 2008 is a hybrid act. Why I call it a hybrid act? The reason behind this is this act is combination of partnership and companies. What happened was this Company Act was firstly enforced in 1986. Later on, it was amended in 2013. Okay, so this act is very old act. Okay, and Partnership Act was made in 1932. So there were many pros and cons of each and every act, whether it is partnership or whether it is company. So limited liability is a midway of both of these acts. The pros and cons of partnership and a company are combined together and this act is formed. The name of the act is Limited Liability Partnership. Why we call it hybrid act? Because it includes features of both company and partnership. Both the features are combinedly available in this act. So one more form of business is sole proprietorship. In sole proprietorship, even one person is starting a business. He's solely doing that business. Then that person, that form of business organization is known as sole proprietary. So it has some features of sole proprietorship also. So this act, limited liability partnership, is basically a combination of various acts, but most of the features here are combination of partnership and company. Okay, so firstly, the initiative to form such kind of business organization was initiated by USA. First initiation to form such kind of organization was taken by USA in bringing LLP legislation, and it was done in 1990. It was done in 1990. So firstly, USA came forward and took some action on forming such kind of organization, such kind of business organization. In this chapter, in this act, we'll be discussing 5 topics. We'll be discussing 5 topics. Only these 5 topics are in your course. First is the meaning. What is the meaning of LLP? Second, it is the objectives of LLP. What are the objectives of forming an LLP? Third, it is the legal framework, that is how a LLP is governed. Who is the signing authority or how it is created, that is known as legal framework. Next, the features of LLP. What are the salient features that is LLP LLP is enjoying? And lastly, it will be the difference between company and LLP and difference between partnership and a company. ठीक है, sorry, partnership and LLP. Differences वाला जो points है, that I'll be discussing together combinedly with the features. Okay, so your homework today will be studying the difference between partnership and LLP and company and LLP. Okay, let's get started. So before starting the act, let us discuss that when this act came into force. Technically, this act came into force on 31st day of March 2009. The provisions of this act was applicable on the country from 31st day of March 2009. But there are 3 dates involved in making of this act, and you'll have to remember all of these 3 dates. Okay, because any question can come in the form of MCQ. First is the date when this bill was passed in Parliament. On 12th of December 2008. On 12th of December 2008, this bill was passed by the members of Legislative Assembly, members of Parliament. Okay, and then on 1st Jan 2009, on 1st Jan 2009, our Honorable President gave his assent. That is, yes, this act is appropriate now, and now the provisions can be applicable on the country. Okay, and lastly, the enforcement date was 31st March 2009. This act came into force on 31st day of March 2009. So now the questions in your examination can be like this. You can be asked that when this bill was passed in Parliament. So don't get confused between the 3 dates. The date of passing of bill is 12th December 2008. Okay, bill was passed by Parliament on 12th December 2008. Now if the question arises when this act came into force, so the date of enactment of this act, date on which the provisions were applicable on the country was 31st day of March 2009, not 2008. They will give you options like 31st March 2008 to make you confused. Like you'll get confused. That is why you know the act was the Limited Liability Partnership Act 2008. So you, in hurry or because of lack of knowledge, you might take 31st March 2008. But just make sure that this act was passed. The bill was passed in 2008, but the provisions were applicable in 2009, not in 2008. Okay, so remember this thing, don't get confused. So the enactment date of this act is 31st of March 2009. If a question arises in exam that when did Parliament, when did President give his assent to this act, then your answer will be 7th January 2009. 7th January 2009. So these are certain dates that you'll have to remember. Okay, so these are certain dates. Second thing that you have to remember is the provisions of this act is applicable on whole of the India. The provisions of this act is applicable on whole of the India. That is the laws related to limited liability partnership will be applicable in similar form, whether it's Kashmir, whether it's Kanyakumari, whether it's Rajasthan, whether it's West Bengal, anywhere in the country, anywhere in India, the provisions of LLP are equally applicable. Just for general knowledge, I want to tell you that the first limited liability partnership was formed on 2nd April 2009 in India. In India, the first LLP was formed on 2nd April 2009. Okay, this question is just for general knowledge, might come into exams, but not sure. Okay, so try to remember this date also. 2nd April 2009, first LLP was made on this date. Now this act has total 81 sections and 4 schedules. This act, the legal framework of this act is, this act combinedly has 81 sections and 4 schedules. Now these 81 sections are not part of your course. Okay, only few sections are part of your course, and I can say only features of LLP is your portion. Okay. Except features, nothing is in your course, no definitions, nothing. Okay, so the basic वैसे तो this act is a very vast act because it has 81 sections. Okay, so but 81 sections are not in the course. So if an exam, if a question in your exams comes like this, that how many sections are there in LLP? So there are 81 sections and 4 schedules. If I talk about meaning of LLP, so if we move to the definition of LLP is given in section 2 subsection N. Okay, but the definition is not clear because the definition of LLP says that it is a partnership firm registered and formed under this act. It is a partnership firm registered and formed under this act. That means what? Any partnership organization which is registered under LLP Act, which is registered under Registrar of Companies under this act is a partnership firm. So the definition is not clear. The features of LLP, if you'll study the features of LLP, then you'll realize the real meaning of LLP. As I'm telling you again and again, LLP is a hybrid form of company and partnership. The cons of partnership and the cons of companies were eliminated and the pros were taken from both the forms of business organization, and a new business organization was formed, and that was known as limited liability partnership. Like for example, if you talk about a partnership business, minimum number of partners and maximum number limit is set, right? I have already discussed that a minimum number of partners in a partnership firm is 2 and the maximum number is 50 or 20. Okay, depending upon the nature of the business. But in LLP, there is minimum limit, so there is there that is two people must be there, then only it will be known as partnership, right? But there is no upper limit, that is maximum limit is not there. So the drawback of partnership was overcome here, that is no maximum limit. Second thing was, in partnership we have studied that if there is death of partners, if there is insanity of partners, if there is insolvency of partner, the partnership gets dissolved. Okay, there is dissolution of partnership. But if we talk about limited liability partnership, it works on the provision of companies, that is, it has perpetual succession. Perpetual succession means that a partnership firm, that is a limited liability partnership, will continue forever, no matter the partners dies, the partner becomes insolvent, the partner becomes insane, because partnership because the partners and the firm are completely different concept, they are considered two different entities. So here this drawback of partnership was also overcome. So by these discussion we can also come to a conclusion, that is the difference between partnership and limited liability partnership. Okay, so firstly we discussed that in limited liability partnership there is a maximum limit of partnership, but in LLP there is no maximum limit. Second is, if there is death, insanity, insolvency, or anything, retirement or something of the partners, then the partnership firm is dissolved. There is a dissolution of partnership firm. But here in LLP, it has perpetual succession. It has perpetual succession, that is whether the partners dies, whether the partners become insolvent or insane or any problem, the firm will continue for infinite number of years. Okay, there is no such provision like the firm will dissolve or something like that. Okay, so here this is a feature of company which is included this limited liability partnership. Okay, so there are many more features that are included in limited liability partnership. Okay, so meaning is that it is an organization which is formed and registered under Limited Liability Partnership Act 2008. Objective, the main objective to form this kind of business is to make your business flexible. That is, this type of business organization enjoys the features of company as well as partnership. Okay, so to overcome the disadvantages of a partnership business and to overcome the disadvantages of a corporation, of a corporate company, this type of organization, that is limited liability partnership, was formed so that there is a flexible form of business. Like for example, if you want to start a if you want to start a partnership business, like normal layman, like for example me, I'm a middle class person. So if I want to start a partnership business, then I'll have to, there is unlimited liability. That is, if I do anything wrong, if I face huge amount of loss, then my personal property can also be taken from me, right? So if my personal property will also be lost, then what will I have, right? So I will have a small fear in myself before starting this partnership business. Why? Because there is unlimited liability. On the other hand, if I want to start a company, starting up of company is very easy. Anybody can start a company, but there are huge amount of formalities that should be fulfilled before forming a corporation, before forming a company. There are n number of forms that you have to file. Then you have to go to the registrar of the company, take permission. If there is any other Section 8 companies or non-profit organization companies or such other companies, you'll have to fulfill many formalities. You'll have to, the fees of starting a company is also high. So you might not be able to afford this kind of fees. So to overcome such problems, a midway was formed where a layman like me, where a normal people can also, because there are no such formalities in this kind of business, there is, and even the concept of unlimited liability is also not here. The name itself is limited liability partnership. That means what? The partnership will have limited liability, like, right? So one more difference we have found, that in partnership there is unlimited liability, and in liability and in LLP the liability of partners is limited. So to a normal layman can also start a business, can also start a proper form of business organization, which is LLP. So the basic objective was this only, that it is a feasible approach, that is anybody can start, it is very flexible, so anybody can adopt this kind of business. There were less formalities as compared to partnership or a company. Okay, so the basic objective of this act was this only. If I talk about legal framework, the provisions here, the this act is governed by the Limited Liability Partnership Act 2008. Okay, if there is any confusion, if there is any doubt, if there is any case, then the provision of this act will be looked upon. Okay, and whatever it is written in the provision of these acts will be followed. Okay, so the legal framework is, this act is governed by LLP Act 2009, and this act was made applicable with the assent of president, and even central government can also be involved in certain matters. Okay, so this is the legal framework. Now the main important part of this chapter, the main I can say the hero of this chapter is features of LLP. If you understand the features of LLP, you'll understand the meaning of LLP. You can also write differences between LLP and company on your own if you understand the features. So that is why I'm telling you that the features of a LLP is the hero of this chapter. Okay, so understand this concept very carefully now. Do you guys have any doubt till here? Okay, let's get to the features wala portion. The first feature of LLP is body corporate. I'll combine first three features and explain the meaning. That is body corporate, separate legal entity, and perpetual succession. All of the 3 points are combined here. First, I talk about if body corporate. The definition of body corporate is a very wide definition, which is not necessary here, because when we'll be studying Company Act, we'll discuss what a body corporate is in very widely. Okay, so here I can say that the definition of body corporate is given in section 2 clause 11 of the Companies Act 2013. Okay, so the definition of body corporate is not given here, but in short, if you talk about body corporate, that means what? Any organization which is called a body corporate is a separate artificial person, is a artificial person created by law. Like we people, like you and me, we have certain rights, liabilities, powers, duties, etc. Similarly, body corporates also enjoys such powers. Like if I talk about partnership business, in Partnership Act, partnership firm cannot be held responsible for anything. Partners are responsible for the firm because partners are acting for the firm. But here, because separate legal entity, because body corporate wala concept is applicable on limited liability partnership, that means what? Limited liability partner itself is an artificial person. Itself is an artificial person. This artificial person has a power to file a suit against the third party. Even the third party has a power to file a suit against the LLP. Like for example, I have created an LLP and the name of my LLP is Megha and Sons. Megha and Sons LLP. Now, if you want to file a case, if you don't want to file a case against me personally or other partners of this firm personally, you can file a case on LLP. That is the in case the name will be written Mr. XYZ versus Megha and Son Limited Liability Partnership. So the entity, the name itself is an artificial person. That is all the natural person. The powers enjoyed by natural persons are similarly enjoyed by a artificial person also. So this is a body corporate where a person where this LLP is an artificial person which is created by law. Second, it is separate legal entity. Separate legal entity means partners are considered separate and firm is considered separate. Okay, so undoubtedly firm itself cannot do all the works by his own because it is an artificial person, not a natural person. Likewise, I told you that LLP itself is having two hands and selling the product. This is not possible. Okay, products or whatever the business is going on, it will be done by the partners, but yet partners are considered separate and this LLP is considered separate. Both are separate legal entity. Okay, that means what? Again, it will be combination of this the above point only. That is a separate suit can be filed against LLP, and LLP also has a right to file a suit against the third party in its own name. It does not require partner's name. Okay. And last is perpetual succession. Third point. Perpetual succession means that this business will go on for infinite period of time. Infinite period of time means if I talk about partnership firm. So I have already discussed this point that if I talk about partnership firm, then in case of death, in case of insanity, in case of insolvency or any such related matters, the partnership firm is dissolved. Okay, but if I talk about limited liability partnership, there is perpetual succession. Perpetual succession means that this firm will continue, the name of the firm will continue for n number of times. Okay, that means what? If the partners dies, if the partners becomes insolvent, if the partners are insane, anything, there is no effect on the existence of LLP. Like for example, I have started Megha and Sons LLP. Now for example, if I die, if it was a partnership firm, then the whole firm would have been dissolved. Okay, but because this is an LLP, it does not matter that I am living or I am dead, the partnership firm will go on forever. Now if I die, then also the LLP will stand firm. Okay, so there will be no effect of my death on the business of the partnership firm. Okay, so this is known as the concept of perpetual succession. That is the business will go on for infinite period of time, no matter the partners are in existence or not. If all the partners dies, then also the firm will continue. Okay, some other person will take over this firm or the government will take over this firm and it will go on with that name only. Okay, so the firm will continue. The firm does not dies. Next feature is registration with registrar of company. Like if I talk about Indian Partnership Act, you have to the registration is mandatory there. So if you want to get your firm registered, you have to go to the registrar of firms. You have to go to the registrar of firms in your nearby area and get your partnership firm registered. But when we talk about limited liability partnership, you have to go to the registrar of company, not registrar of firms. Okay, so don't get confused. If I talk about registration, if you want to get your LLP registered, you'll have to go to the registrar of company and get your LLP registered there. And registrar of company will be the nearby ROC of your state in which you are commencing your business. Like if I'm starting this LLP in Jodhpur, Rajasthan, so I'll go to the ROC of Rajasthan, I'll go to the ROC of this state, and then I'll get my this LLP registered. I cannot go to the ROC of Maharashtra and get my ROC registered because my place of business is in Rajasthan. So wherever your place of business is, you'll have to go to the ROC of that state and you'll have to get your LLP registered there. So a clear cut question can come into your exams, that is where LLP is registered. So there will be 4 options. In that options, one option will definitely be registrar of firms. So what you'll think at that time, if you haven't studied properly, you'll think that this is limited liability partnership, and partnership is combination, combinedly partners are known as partnership firm. So it might get registered under registrar of firms, but don't get confused there. Partnership Act says that partnership is registered by registrar of firms, but Limited Liability Partnership Act says that a limited liability partnership is registered by nearest registrar of company of your state where your business is going on. So do not get confused. Okay, so this is one more difference between LLP and partnership. That is, partnership firm is registered under registrar of firms and LLP is registered under registrar of companies. Okay, so the registration is with ROC. Next feature is not application of Partnership Act. None of the provision of Partnership Act are applicable on limited liability partnership. This act is governed by its own provisions. Okay, so Partnership Act की provisions are not applicable on LLP. Next is business for profit and not for charitable or non-economic purpose. Just to make sure, if you want to start any non-profit organization, if you want to start any trust, if you want to start any charitable organization, there you cannot form an LLP. An LLP cannot be formed where there is not for profit organization. Okay, so because the main purpose you are forming a business, LLP is a business organization, and why do you do business? You do business for earning profit. The ultimate motive of forming any kind of business is profit. Okay, so if you are doing any non-profitable works, then an LLP cannot be formed for non-profitable purposes. Difference between firm and a company. We have already discussed this topic in Partnership Act. There are many differences between a firm and a company. Okay. In this chapter, we'll be discussing difference between LLP and a company. But still, if you want to know, then there are few differences. First is Indian partnership firm is registered under registrar of firms and company is registered under registrar of company. Second difference between firm and company is if there is death of partners, then partnership comes to an end. But if there is death of members, if there is insanity of members of a company, the company does not comes to an end. That is, perpetual succession is not applicable in partnership firm, but it is applicable in company. One more difference between partnership firm and company is in partnership firm, maximum and minimum number of partners is determined, but in company there is no such limit. Partnership business cannot launch its shares to the open market, but companies can launch its shares. It can demand capital from other members also. Indian firms are governed by Indian Partnership Act 1932 and company is governed by Companies Act 1872 or 2013, whichever is applicable. Okay, so there are many differences between partnership firm and a company. Okay, let's get back to the topic. So we were on the point that business for not profit. So if you are planning to start any NPO, if you are planning to start any charitable trust, then you are not allowed to make any LLP there. Okay, LLPs are just for firm. But a firm means the organization of partners. If two partners, if three partners, four partners are working together, then combinedly their organization will be known as partnership firm. They'll be combinedly known as partnership firm. So I was talking about business for profit. If you're planning to do any non-profit organization, form any non-profit organization, then you cannot form an LLP. So LLP, formation of LLP is not allowed for NPOs, for charitable trust, etc. Next difference is minimum and maximum number of partner. If we talk about partnership business, minimum number of partnership, minimum number of partners is 2 and maximum is 20 in case of banking and 50 in case of other corporations. Okay, but when we talk about LLP, minimum is for sure it is 2. Before if you are not 2 people, then you cannot start a partnership business. So minimum number of members in an LLP is 2 and there is no upper limit. That is, maximum number of partners are not decided here. You can have as many partners as you want. So there is no limit for this maximum limit. But you'll have to make sure there are 2 designated partners. There are 2 designated partners. What is the concept of designated partners? The partner who is doing work, who is managing the entire LLP are known as designated partners. You'll have to get your 2 names registered as designated partners. That is, these 2 people will be responsible for the entire LLP. There may be any partners. There may be n number of partners in an LLP, but minimum there should be 2 designated partners in a limited liability firm. Like for example, I have created LLP Megha and Sons. So in this LLP, I must have 2 people, minimum 2 people who will be registered as designated partners with the registrar of company. Okay, there is necessity. And among these 2 people, one should be sure resident of India. Okay, if both the partners who are registered as designated partners lives abroad, who are not residential Indians, so they will not be allowed. Okay, one in whatever number of designated partners you have, one must be resident of India. Okay, वैसे तो you are allowed to make NRI also designated partner, but one partner should be Indian. That is, one partner should be resident of India. So this designated partner, maximum limit, if I talk about in LLP firm, then there is no maximum limit. N number of partners can be appointed. And minimum, if I talk about, there must be 2 members for starting such business, and there must be minimum 2 designated partners if you want to start a LLP. Next is management of business. Partners combinedly can manage the entire LLP. Okay, partners combinedly or any 2-3 people, whatever the scenario is, can manage the LLP. Now, for example, I have created an LLP Megha and Sons. There are 10 partners in this LLP. Now, Megha and XYZ, 2 are the designated partners. Megha and XYZ are 2 are the designated partners. Now the work here is done by all the partners. All the 10 partners are working together and earning profits. So I can say that this LLP is managed by all the partners. But in case of any misconduct, in case of any consequences, the legal action will be taken either on the firm, that is either on the LLP or on the designated partners only. Okay, so legal action will be taken on partners. Designated partners are responsible for the actions of remaining partners. Okay. So basically, LLP can be managed by any partner, can be managed by any partner or all the partner, but responsibility of legal action shall be on designated partners only. So this is the management of business. Next is no mutual agency. If I talk about a partnership firm, in that case, we have studied that all the partners are agent of each another. In partnership concept, the concept of PAP is applicable. PAP means what? Principal, agent, principal. That means what? PAP, PAP. That means what? Each partner is the principal as well as agent of another, right? So, but if I talk about a LLP, then no one partner can be bound by the works of another partner. Now, in that partnership business, if Mr. X has done something wrong, the consequences could be taken on Y, Z, anybody. But here in LLP, if Mr. X has done something wrong, we can only bind Mr. X. Mr. Y cannot be involved. Although both are partners, but they are not in a partnership firm. They are running a LLP. So mutual agency wala concept is also not applicable on this partnership business. Okay. LLP, limited liability partnership. So mutual agency is not applicable on limited liability partnership. No partner can bind another partner for his conduct. Okay, every partner is separate. Next is agreement for mutual rights and duties. Here, rights and duties are quite flexible. That is, partners amongst themselves are allowed to form their own rights, are allowed to form their own responsibilities, duties, etc. But in case they are unable to form, unable to decide the rights and duties, then in that case, in such absence, the LLP Act 2008 shall be referred. Okay, whatever will be written in the provisions of this act shall be applicable. But in normal sense, if I say that agreement, if we talk about mutual rights and liabilities, the concept is very flexible. That is, partners can decide their own rights and liabilities. No such statute is formed, that is, you'll have to, these are the rights or duties of the partners. No, you can decide it by your own, but there are some rights and duties which are registered in LLP. If you do, if in case of absence of any rights and duties, the act can be referred. Next is annual account and next is liability of partners. If we talk about partnership business, if we talk about partnership firm, in a partnership firm, the liability of partners are unlimited. Okay, that is, in case of any insolvency, in case of any loss, personal property of the partners can also be involved. But if I talk about the concept of limited liability partnership, here the liability of partners is limited. Here the liability of partners is limited to the extent that they have contributed towards the business. Now, for example, I have started the LLP and I have contributed 1 lakh rupees to this LLP. So in case of any loss, in case of any mishappening, I will be accountable only till the extent of 1 lakh. Okay. Now, for example, there is a loss of 1 crore and combinedly all the partners have just contributed 1 lakh rupees. So here we will contribute only 1 lakh. Our personal property will not be taken into account here because we have limited liability. Only to the extent that we have bought to the capital we have bought to the business, whether it is tangible or intangible. Like some people brings their goodwill with themselves, so they will be accountable for that extent only. Okay, so in limited liability partnership, the liability of partner are limited to the contribution they have done towards the firm. Okay, whether it's in the form of tangible or intangible. Next is annual accounts and audit. In an LLP, you are required to maintain books of accounts. You cannot switch, you cannot skip any accounting information. There are strict rules that you'll have to, it is mandatory that you'll have to maintain all the proper accounts of the business of the organization. Okay, and it is also necessary that you'll have to submit your account statement, your annual account statement, as well as solvency statement, to the registrar of the company every year. Okay, so there is no such provision in partnership business. But when we talk about LLP, in this case, if you are working as an LLP, as a limited liability partnership, in that case, firstly, it is mandatory that you'll have to maintain your annual accounts, and second, you'll have to maintain, submit your annual account statement as well as solvency statement to the registrar of the company every year. Okay, next we talk about power of central government into LLP. Like in Partnership Act, central government does not have many powers. Or if we talk about corporates, company, there also central government does not have many powers. But if a central government, if the central government finds something fishy in the LLP, like the central government thinks that there is something wrong going on this LLP, because LLP is a hybrid form of company as well as partnership. So there are chances that people create LLP to save themselves from income tax or to do some fraudulent activities. So to avoid such kind of things, it is stated that if the government wants, if the central government wants, central government can appoint an inspector, can appoint a competent inspector to investigate the LLP. Like central government finds that there is something wrong going on Mega and LLP. So the central government has a power to appoint a competent inspector who will come to my company, or who will come to my firm, my limited liability partnership firm, and can demand anything from me, can demand any books of accounts, can demand any document related to this year or related to any year. Okay, so central government has a power to appoint a competent inspector in case they wants to. Next is conversion of firm and company into LLP. As I told you that limited liability partnership also does not have many formalities. So any company or any partnership firm that want to convert itself into a limited liability partnership, they can easily convert themselves into limited liability partnership by fulfilling certain formalities. Next is winding up of LLP. Winding up of LLP is completely voluntary. If you want to wind up your LLP, you can, but there is no such provision that you'll have to wind up only. Like if I talk about partnership business, in a partnership business, if the partners dies, or if there is new admission of any partner, if there is retirement of any partner, if there is insanity of any partner, if there is insolvency of any partner, then the partnership firm is dissolved. There is dissolution. Dissolution means winding up only. If I talk about company, then in case of insolvency, etc., you can wind up a company also. But when I talk about the LLP, limited liability partnership, here, because it has a perpetual succession, that is, here it says that this form of business will go on for infinite period of time, and it also has separate entity concept, that is, business is separate and business men is separate. So here, because of these two concepts, we can clearly state that here in an LLP, winding up is completely voluntary. If you want to wind up your company, you can, but there is no such compulsion. That is, for example, if your partners died, then this business will go wind up. No, there is no such provision. If you want to continue, like for example, in my LLP, all the partners died, but some other people came and purchased this. Like for example, Vijay Mallya, everybody must have heard about Vijay Mallya. Vijay Mallya was the owner of the Kingfisher company, right? So in that case, Vijay Mallya was insolvent. Okay, he was not able to clear all his dues. So Vijay Mallya escaped from the country. So the name of Vijay Mallya was excluded from the company. But some other people came purchase this Kingfisher. Kingfisher company is still date in existence, but all the partners, all the members have changed. Similarly, LLP, this feature of company is applicable on LLP also. That is here winding up is compulsory. Whatever the situation is, the company, the LLP, that is limited liability partnership, can continue for infinite period of time. LLP can also be wound up by establishment of tribunal. Okay, if you want to wind up, then you can establish a tribunal to just wind up your organization. Next feature is appointment of company act provision with changes and modification. Here central government also has one more power, that is if central government wants, central government can apply the provisions of Companies Act on limited liability partnership. Okay, so if there is some absence in the act, or if the government finds it appropriate that despite of applying the provision of LLP, I shall apply the provisions of Companies Act, because it is a hybrid form. It is a mixture of both partnership and company. So the central government has a power that rather than applying the provisions of limited liability partnership, in case of any problem, in case of any dispute, central government has a power that it can also apply the provisions of Companies Act. And central government also has one more power, that it cannot apply, it has a power that if central government wants, it cannot apply the provisions of Companies Act as it is. It can also modify, or it can also change some provision and make it applicable as per their requirement, as per they want. Okay, so here the central government has a power that they, in case of any dispute, in case of anything, the central government has a power to apply the provisions of Companies Act in your limited liability partnership. Next is e-filing of documents. If I talk about registration of a firm, if I talk about registration of a company, then in that case you'll have to physically go to the registrar of the company or registrar of the firms and get and file all the documents and fill all the forms, and then you will start the business. But in limited liability partnership, there is one easy concept, that is for your ease, because the country is going digital. So a website is formed. The name of the website is www.llp.gov.in. Okay, so this website is officially formed by the government. Here all the manual forms, application documents, forms, etc. are present. You can fill it there and you can send it to the registrar of company via electronic form. Okay, so filing, getting your LLP registered is very easy. You can also do it online. So a website is clearly formed, which is the name of the website is www.llp.gov.in. Okay, so on this website, different forms, different documents that are required to register your LLP are there. You can fill it there. You can attach your e-signature and you can submit those to the registrar. Online submission is also an option if you want to. And last is foreign LLPs. Like partners, one LLP can be a partner of another LLP also. Okay, like Megha LLP wants to join some other LLP, so I can join by the name of my LLP. So if there is any foreign LLP, then foreign LLPs are also allowed to become a partner in an Indian company. Okay, if there is an Indian company, then any foreign LLP is allowed to enter as a partner. So these are the basic features. These are the basic features of limited liability partnership. So from the basic features, the meaning of LLP is very clear. That is, a limited liability partnership is a hybrid, is a combination of partnership firm and corporation. it enjoys the benefits of company as well as partnership. The drawbacks of partnership, the drawbacks of companies are a solution. Okay, a solution for this limited liability partnership. So I hope the features wala part is clear. The difference between partnership and an LLP and company and a LLP, you're going to read it, because company difference between company and LLP I haven't discussed much, because to study the differences, firstly you'll have to understand what a company is. You know what a partnership firm is. That is why I was continuously telling you the differences between partnership and LLP, but you don't know what a company is yet because you haven't done that chapter. Once we complete the Companies Act, then we'll discuss the difference between company and an LLP. Okay, so your homework today will be, you'll read the difference between partnership and limited liability partnership, and in the next class you'll tell me if you do not understand any point. Make sure you do your homework. Okay, make sure that, because I might ask that what are the differences in the next class. Try to read the differences between company and LLP also, but in that portion if you don't understand anything, then also there is no problem, because in future when we'll be discussing this Companies Act, at that time when we'll finish that act, then I'll again come to this topic, that is difference between company and LLP. So here today we have completed one more chapter, that is limited liability partnership. So this chapter, the complete chapter, Indian Partnership Act 1932 and LLP, here it is completed. Okay. If you have any doubt till here, ask me here. And if you don't have any doubts, then you can leave the class. That's all for today. Okay. Thank you, everyone. If you have any doubts, you can ask me here. I hope everything is clear to you, right? Okay. Thank you, everyone.